Does Patrick being out make this case more dangerous or more transparent? That's the question people are arguing about. But it's the wrong place to start, because the headline is loud and the court reality is quiet. In 2026 reporting, John Patrick Roark was arrested on January 16, 2026. Days later, on or about January 23, 2026, he was released pending the case after a $150,000 bond was posted. That fact alone triggered a wave of assumptions that moved faster than the record ever could. So we start by slowing this down. Released pending a case is not a finish line. It is not an exoneration. It is not a declaration of innocence. It is a procedural status change. And if you don't understand what that actually means, everything else that follows will be distorted. When courts release someone pending trial, they are not weighing guilt versus innocence. They are weighing risk. Risk of flight. Risk to public safety. Risk of interference. Risk of noncompliance. And those decisions are made early with limited information under specific legal thresholds. The charges reported in this case did not disappear with release. They remain serious and specific. 5 felony counts of financial exploitation of an incapacitated person. 5 felony counts of fraudulent schemes. 1 felony count of fraudulent use of an access device. Those are not internet labels. Those are statutory allegations that now sit inside a court process. And once they are filed, the case belongs to the system, not to public opinion. So what does release actually mean right now? It means he is not physically in a jail cell today. It means the state still intends to test these allegations in court. It means the defense now prepares outside custody rather than inside it. Nothing more, nothing less. This is where people get tripped up. They hear bonded out and imagine a door closing behind the case. But bond is not an exit. It's an agreement, a legal contract with teeth. Appear when ordered. Follow conditions. Stay inside boundaries. Violate them. And release can evaporate fast. That's why the real question isn't, why was he released? The real question is, what does release change right now legally, practically, and emotionally for this case and for the Whittaker family? Because even when charges stay the same, the environment around vulnerable people can change overnight. And environment matters. Release pending shifts the case into a new phase, a quieter phase on paper, a louder phase in real life. Inside the courtroom, things become procedural. Timelines, filings, discovery, motions, conditions, compliance. Outside the courtroom, attention often spikes. Commentary returns. Narratives resurface. People reinsert themselves into a story they don't control. That's the risk zone, because the legal system can handle allegations. What it can't easily contain is chaos. This case is not happening in a vacuum. It's happening after months of intense public attention, after allegations of exploitation, after reported state intervention, after a vulnerable family became a symbol rather than a household. Release doesn't rewind that. It can intensify it, and that's why the dangerous versus transparent question exists at all. Transparency comes from records, filings, and conditions being followed. Danger comes from pressure, interference, and boundary erosion. So before we even talk about what might happen next, we have to be clear about what did not happen here. No court declared this case weak. No judge ruled the allegations unimportant. No finding was made on guilt or innocence. The court allowed the case to proceed with the accused outside custody under financial and behavioral conditions. That distinction matters more than any headline, because release pending trial is not about closure. It's about control. Control of risk, control of process, control of behavior while the system does its work. And the moment someone is released, the focus quietly shifts from arrest to compliance. That's where the next chapter lives. Not in speculation, not in celebration, not in outrage, but in conditions. Conditions are the invisible spine of a case like this. They don't trend, they don't go viral, but they decide whether a case moves forward cleanly or fractures under pressure. Which brings us to the part people almost always skip. Bond is not just money, it's rules. Rules about where someone can go, who they can speak to, what kind of contact is prohibited, what happens if those rules are tested. And in cases involving alleged exploitation of vulnerable individuals, those rules often matter more than the charges themselves. Because the system isn't only trying to prove what happened, it's trying to prevent further harm while it figures that out. That's why the atmosphere matters. A vulnerable family doesn't experience release as a legal abstraction. They experience it as a shift in emotional gravity. Fear can resurface. Uncertainty can spike. Old wounds can reopen even if no one violates a single rule. This is something public commentary rarely acknowledges. The case can be stable on paper while the human cost quietly rises. And that's why the most responsible way to follow this story isn't to ask whether release proves anything. It's to ask what guardrails are now in place and whether they hold. Because release pending trial is not freedom. It's a test of compliance, a test of restraint, a test of whether this case stays inside the courtroom or spills back into real lives. That's the pivot point. So now that we've stripped away the noise, we can move to the mechanics that actually matter. Not opinions, not theories, not internet verdicts. Paperwork. In the next part, we're going to break down what a bond headline actually represents, why the number itself is often misunderstood, and why the rules attached to it matter more than the amount. Because if you want to know whether this becomes transparency or danger, the answer won't come from the comment section. It will come from compliance. Dangerous or transparent? And why? Bond numbers sound dramatic, but they're mostly paperwork with consequences. When people see $150,000 bond, they tend to hear a moral statement. Too high means the court thinks he's dangerous. Too low means the court doesn't care. But bond isn't a moral judgment. It's a risk calculation made early, with limited evidence, under strict legal standards. So let's take the emotion out of the number and talk about what bond actually is. Bond is a conditional release agreement between the court and the defendant. It answers one narrow question. Can this person be released while the case proceeds, without undermining the process? It does not answer whether the person is guilty. It does not measure the strength of the case in a final way, and it does not protect anyone by itself. The bond amount is only one piece. The conditions attached to it are the real story. In many cases like this, what's reported as bonded out usually means a surety bond. That's when a bonding company posts a guarantee to the court in exchange for a fee. The defendant doesn't walk away clean. They walk away under supervision, financial obligation, and strict rules. Miss a court date, the bond can be forfeited. Violate conditions, the bond can be revoked. Trigger new concerns, restrictions can tighten fast. That's why bond isn't freedom. It's leverage, and leverage cuts both ways. From the court's perspective, bond creates incentive to comply. From the defendant's perspective, it creates constant exposure. Every action, every post, every indirect interaction can matter more once release happens. This is where public misunderstanding becomes dangerous. People often assume that once someone is released, the pressure is off. In reality, pressure often increases, because when you're out, you have more opportunity to comply and more opportunity to violate. That's why the question isn't, how did he get out? The question is, what is he allowed to do now? And in a case involving alleged exploitation of vulnerable people, that question becomes critical. One condition that often appears in cases like this is no contact. Not always publicized, not always detailed in reporting, but central to protecting people who cannot easily protect themselves. No contact doesn't just mean don't show up. It can mean no calls, no messages, no third-party communication, no indirect pressure, no using other people to pass information or influence. In the digital world, that boundary is harder to maintain than people realize. Indirect contact can happen through social media posts, through shared acquaintances, through public statements meant to be seen by specific people. Courts are aware of this, which is why violations don't always look dramatic. Sometimes they look subtle. That's why bond conditions are often written broadly, not to punish, but to prevent destabilization while facts are still being tested. And this is where release can make a case either clearer or more volatile. When someone is in custody, access is limited. Communication is constrained. Influence is contained. When someone is released, the system relies on compliance instead of confinement. That's a risk-based choice. Now, here's the part that gets overlooked. Bond conditions don't just protect the public. They protect the integrity of the case. They prevent interference with witnesses. They reduce pressure on vulnerable parties. They keep the process from being hijacked by emotion or intimidation. That's why violations are taken seriously. If conditions are followed, the case proceeds cleanly. Evidence is reviewed. Motions are filed. Hearings are scheduled. The legal system does what it's designed to do slowly, methodically, and quietly. If conditions are violated, everything changes. Bond can be revoked. Release can end. Restrictions can escalate. The court's posture can harden. And that shift can happen fast. This is why bond headlines are misleading. They suggest finality where there is none. They imply leniency where there may be strict oversight. They turn a procedural step into a narrative conclusion. But the court hasn't concluded anything yet. What it has done is move the case into a phase where behavior matters more than statements. And that's not just about the defendant. It's about everyone around the case. Because once someone is released, the environment becomes more sensitive. People react. Content ramps up. Opinions harden. The temptation to get involved returns. That's where vulnerable families face the most risk, not from a single act, but from cumulative pressure, messages, speculation, visits, fundraisers, people claiming insight or authority. None of that needs to violate a law to cause harm. This is why courts often rely on confidentiality and distance when vulnerable adults are involved. Locations may be protected. Information may be limited. Silence may be intentional. Silence is not inaction. It's containment, and bond conditions are part of that containment strategy. So when people ask whether release makes this case more dangerous or more transparent, the honest answer is, it depends on compliance. Release can increase transparency if everyone respects boundaries and lets the process work. It can increase danger if pressure, interference, or indirect contact resumes. That's not speculation. That's how these cases actually function. The bond amount didn't decide that. The conditions did. And the next phase of this case will be shaped less by what people believe and more by what people do or don't do. Which brings us to the most important shift that happens after release. The case moves from custody to conditions. From, is he jailed? To, are the rules being followed? From, what happened? To, what happens next if something goes wrong? In the next part, we're going to look at what changes immediately once someone is released pending trial, specifically around access, speech, and contact, and why those three areas determine whether this case stabilizes or spirals. Because the loudest risks aren't always the obvious ones, and the quietest violations are often the most consequential. Comment below. Do you think bond conditions matter more than the bond amount itself? Yes or no? And why? The moment someone is released pending trial, the case doesn't relax. It reconfigures. From the outside, it can look like relief, like momentum has shifted, like the system blinked. But inside the legal process, release marks a transition into a phase that is often more delicate, not less. Everything pivots around three areas: access, speech, and contact. These aren't abstract concepts. They're pressure points, and how they're handled determines whether a case stays procedural or starts to fracture under real-world interference. Let's take them one at a time. Access. Movement and opportunity. Access is the most obvious change. When someone is in custody, access is restricted by default. Movement is limited. Meetings require coordination. Documents move slowly. Communication is filtered. The environment itself imposes friction. Release removes that friction. Access now includes freedom of movement, easier meetings with legal counsel, quicker handling of paperwork, and more autonomy in daily life while the case proceeds. That can be entirely appropriate. It can also accelerate the pace of the case. This is where people get it wrong. They assume release slows things down. Often, it does the opposite. Defense preparation becomes easier. Evidence can be reviewed more efficiently. Strategy can be discussed without barriers. Filings can be drafted faster. Deadlines become real instead of theoretical. From the prosecution side, the same thing happens. Once the case moves out of the arrest phase and into the release pending phase, timelines sharpen. Discovery issues get formalized. Motions get scheduled. Hearings get locked in. In other words, the case becomes louder on paper even if it looks quieter in headlines. But access isn't just about lawyers. It's about proximity. And in a case involving alleged exploitation of vulnerable people, proximity matters. That's why access is almost always paired with restrictions, geographic limits, supervision rules, stay-away provisions. These aren't symbolic. They're designed to prevent instability while facts are still being tested. The court isn't saying, you're free. It's saying, you're out, under control. And control depends on compliance. Speech, what can be said, and what it can trigger. Speech is where release becomes complicated in the modern world. When someone is in custody, speech is constrained by circumstance. Access to platforms is limited. Public messaging is harder. The narrative tends to pause. Release changes that instantly. Now, there is the ability to speak publicly, to post, to respond, to frame events, to deny allegations, to influence how the story is perceived in real time. Courts are deeply aware of this. That's why speech can become a risk factor even when it's technically legal. Because speech doesn't exist in a vacuum. It creates reactions. It moves audiences. It can signal things indirectly without ever naming them directly. In high-profile cases involving vulnerable individuals, speech can destabilize even without intent. A post doesn't have to name someone to be felt by them. A statement doesn't have to threaten to create pressure. A denial doesn't have to be aggressive to invite retaliation from supporters. The system understands this dynamic better than the public often does. That's why you'll sometimes see courts caution against public commentary, even when they can't outright prohibit it, because speech can function as indirect contact, as signaling, as influence. And once speech creates pressure, the harm is already done even if no rule is technically broken. This is why responsible reporting matters, and why restraint matters even more, because every public statement can ripple outward, toward witnesses, toward family members, toward people whose lives are already fragile. Release gives someone a microphone again. The question is whether they use it, and how the system interprets that use. Contact, the most sensitive line. Contact is the most critical and the least understood. In cases involving alleged exploitation, contact isn't just about physical proximity. It's about influence. That's why no contact conditions, when they exist, are written broadly. No direct contact. No indirect contact. No third-party messaging. No just checking in. No using intermediaries. Because indirect pressure can be just as destabilizing as direct interaction. In a digital world, indirect contact can happen without anyone meaning for it to happen. Someone posts something. Someone else shares it. Someone tags a name. Someone comments. Suddenly a boundary is crossed without a single message being sent. Courts know this. That's why violations aren't always obvious. Sometimes they're about patterns, not moments. About influence, not words. This is also why public involvement becomes dangerous at this stage. Supporters who think they're helping can unintentionally create problems. Detractors who think they're exposing something can escalate risk. People inserting themselves into the story can generate contact that no one authorized. And none of that protects the vulnerable. In fact, it does the opposite. Contact rules exist to keep emotional, psychological, and situational pressure away from people who are already carrying too much of it. When release happens, the system isn't just watching the defendant. It's watching the environment. Is pressure increasing? Is attention spiking? Is the story being reactivated in ways that could harm people who didn't choose this spotlight? That's the unspoken concern. Two realities at once. Release pending trial creates two realities simultaneously. On one side, it allows the legal process to move more efficiently. Preparation becomes easier. Paperwork flows. The case takes shape. On the other side, it increases the stakes of compliance, because the court has now trusted the defendant to stay within boundaries without physical confinement. That trust is conditional, and conditional trust can be withdrawn. This is why release is not leniency. It's exposure. Every action now happens in open air. Every misstep is visible. Every indirect effect matters more. The margin for error is smaller, not larger. This is also why people misunderstand what it means to be out. Being out doesn't mean the case is weaker. It doesn't mean the court is unconcerned. It means the system believes it can manage risk through rules instead of walls for now. And that for now carries weight. Why this phase is often the most volatile. Historically, the period after release pending trial is when cases either stabilize or spiral, not because of what's proven, but because of what's triggered. If boundaries hold, the case proceeds quietly. If pressure escalates, the court intervenes. This is where escalation doesn't come from new evidence. It comes from behavior. That's why courts watch closely. That's why conditions matter more than headlines. And that's why the question isn't whether Patrick being out changes the facts. It doesn't. The question is whether it changes the temperature. Because temperature determines everything around vulnerable people. And once temperature rises, it's hard to cool it back down. In the next part, we'll look at why release can actually speed a case up, how active investigations intersect with this phase, and why the system often tightens rather than loosens after someone is released. Not because of punishment, but because of risk. And risk, in cases like this, is not theoretical. There's a common assumption that when someone is released pending trial, the case loses momentum, that the pressure eases, that things drift. In reality, many cases do the opposite. They accelerate. Release often marks the moment when a case stops being a headline and becomes a timeline. When someone is in custody, everything moves through constraints. Scheduling is slower. Meetings require coordination. Access to documents is limited. The system accepts that friction because confinement itself is a form of control. Once release happens, that friction disappears. And when friction disappears, the process sharpens. Defense counsel can meet more frequently. Strategy can be refined in real time. Discovery review becomes more efficient. Motions can be filed without delay. Calendars get set. Deadlines stop being theoretical and start being enforced. On the prosecution side, the same thing happens. Once the arrest phase ends and the case enters a release pending posture, the state begins locking in its roadmap. Evidence is organized with trial in mind. Witness lists are refined. Discovery obligations are triggered. Decisions are made about scope. This is often the moment when prosecutors decide what the core of the case will be, not what makes the loudest headline, what can actually be proven. And that matters here, because reporting around this case has described an investigation that remains active. That detail is easy to overlook, but it's critical. An active investigation means the record may still be developing. It means authorities may still be gathering documentation, still tracing financial pathways, still interviewing people who haven't spoken publicly. Release does not pause that work. If anything, it can intensify it. Because once someone is out, the court expects progress. It expects filings. It expects movement. It expects the case to either narrow or harden. This is the phase where prosecutors often decide whether to streamline charges, consolidate theories, or prepare for expansion if corroboration emerges. It's also the phase where defense teams decide whether to push aggressively, negotiate quietly, or wait and see how the record shapes up. That's why release pending trial is often louder behind the scenes than during detention. The work becomes real, but the biggest acceleration isn't just legal. It's environmental, because while the system focuses on paperwork, the public often focuses on presence. He's out. He's free. He's back. Those phrases carry emotional weight, especially in cases involving vulnerable people. They can reignite attention that had begun to fade. They can pull the story back into circulation. They can invite commentary from people who feel compelled to insert themselves again. This is where risk multiplies, not because of one person's actions, but because of collective behavior. Public attention doesn't watch quietly. It reacts. It speculates. It organizes. It amplifies. And vulnerable families don't get to opt out of that amplification. That's why release can feel destabilizing even if nothing legally changes, because it changes the atmosphere. It can bring back curiosity seekers. It can invite opportunists. It can trigger new donation schemes that borrow a familiar name. It can revive harassment campaigns that never fully disappeared. None of this requires a single court rule to be broken. Attention alone can destabilize a fragile situation. This is why courts are cautious about public-facing cases involving incapacitated or vulnerable individuals. Confidentiality exists for a reason. Distance exists for a reason. Silence exists for a reason. Not to hide information, to prevent harm. And this is where people often misunderstand the system's posture. When officials say little, it's not always because nothing is happening. It's often because they're trying to keep the environment calm while the case tightens. Release pending trial doesn't mean the system is stepping back. It means it's shifting its method. Walls are replaced with rules. Confinement is replaced with conditions. Silence is replaced with compliance monitoring. And compliance monitoring is unforgiving. Every interaction now exists in a wider field of consequences. Not just legal consequences, but practical ones. If public pressure escalates, agencies respond by tightening access. If interference increases, restrictions harden. If instability returns, the system prioritizes containment. This can mean more confidentiality, not less. More distance, not more openness. More control, not more freedom. Ironically, the more chaotic the environment becomes, the less transparent the case feels to the public. That's how release can lead to escalation instead of clarity, not because of what's proven, because of what's triggered. And this is where responsibility shifts outward. At this stage, the safest thing for the case is often restraint, not silence born of fear, but silence born of respect for process. Letting documents speak, letting timelines unfold, letting conditions do their work. Because when the public tries to help by pushing, speculating, or intervening, they often make things worse for the very people they claim to care about. Vulnerable individuals don't benefit from renewed attention. They benefit from stability. And stability requires fewer voices, not more. This is the tension at the heart of release pending trial. Legally, the case becomes more active. Socially, it becomes more volatile. And those two realities pull in opposite directions. The legal system wants quiet compliance. The internet thrives on noise. Only one of those produces resolution. That's why the question of dangerous versus transparent isn't about the defendant alone. It's about whether the environment allows the case to proceed without interference. Transparency comes from verified filings, not speculation. Danger comes from pressure, not proof. Release doesn't choose between those outcomes. Behavior does. And not just the behavior of one person, the behavior of everyone watching. This is where the public has a role, even if it's an uncomfortable one. Watch. Verify. Wait. No doxing. No visiting. No contacting anyone involved. No fundraising in someone else's name. No treating real people like a storyline you can interact with, because once the system has stepped in, interference doesn't help. It delays. It complicates. It hardens boundaries. And when boundaries harden, the people at the center often pay the price. Release pending trial doesn't answer the case. It tests whether the case can survive attention, and that test is happening now. By the time a case reaches this phase, most of the drama people fixate on has already passed. The arrest happened. The release happened. The headline ran. What remains is quieter, slower, and far more decisive. This is the compliance phase. Release pending trial is not freedom in the way the public imagines it. It is conditional existence inside a legal box. Every step taken, every word spoken, every interaction allowed or prohibited sits inside that box. And the box is defined by court conditions. Those conditions are not suggestions. They are the spine of the case. Moving forward, this is where many high-profile cases turn, not because of new accusations, but because of violations. Courts are less tolerant during this phase than at almost any other point. Once a judge has decided someone can await proceedings outside of custody, the expectation is absolute compliance. No ambiguity. No creative interpretation. No, I didn't mean to. Especially in cases involving alleged exploitation of vulnerable people. If conditions include no contact provisions, those provisions matter more than any public statement. No contact does not mean no physical visits only. It can include indirect contact, third-party messaging, social media signaling, public statements meant to reach protected individuals, or encouraging others to do what the defendant is prohibited from doing themselves. Courts look at effect, not intent. If a condition exists to protect vulnerable individuals, anything that undermines that protection is treated seriously. This is why the idea of dangerous versus transparent hinges less on release itself and more on what happens after. Transparency comes from restraint. Danger comes from testing boundaries. The legal system is built around the idea that if someone can follow rules under scrutiny, the process can move forward without escalation. If they cannot, the system responds quickly and forcefully. Bond can be revoked. Conditions can be tightened. Custody can resume. And once that happens, the court's posture changes. Judges do not like uncertainty in cases involving risk. They do not tolerate instability around protected individuals. And they do not reward behavior that invites chaos into an already sensitive situation. That's why compliance is the hinge point, not guilt or innocence, not public opinion, not internet narratives. Compliance. This is also the phase where silence becomes strategic. Anything said publicly can be misinterpreted, misused, or misunderstood. Anything amplified by others can take on a life of its own. And while people outside the case may feel entitled to commentary, the court does not care about entitlement. It cares about control. This is where defense teams often pull their clients inward. Less posting, less commentary, less engagement, not because they're hiding something, but because noise creates risk. On the prosecution side, this is where attention sharpens. Compliance is monitored. Patterns are noted. Behavior is observed. The system watches not for drama, but for consistency. This is also where the environment around the Whittaker family matters more than ever. If public pressure remains low, if attention stays contained, if boundaries are respected, the system has space to work. If attention escalates, if people attempt to intervene, if third parties insert themselves, agencies respond by tightening everything. More confidentiality, more distance, more restriction, not as punishment, but as containment. And containment always reduces transparency. This is the paradox many people miss. The more aggressively the public demands answers, the fewer answers become available. The system doesn't respond to pressure with openness. It responds with control. So if the goal is clarity, the path isn't noise, it's patience. The only things that meaningfully advance understanding from here are documents and dates, verified court filings, scheduled hearings, recorded motions, official statements tied to the record, not screenshots, not secondhand claims, not anonymous messages. Everything else is static. And this brings us to the final distinction that decides whether this phase becomes closure or escalation. Who controls the narrative? If the narrative is controlled by verified court process, the case moves toward resolution. If the narrative is controlled by speculation, outrage, or interference, the case hardens and fractures. For vulnerable families, that fracture is not abstract. It shows up as instability, anxiety, and loss of peace. The system's job is not to satisfy curiosity. It is to reduce harm. Release pending trial doesn't make a case safer or more dangerous by itself. Behavior does. Compliance does. Restraint does. And the public's role, whether people like it or not, is minimal. Watch. Verify. Wait. Anything more risks becoming part of the problem. This case will not be decided by comment sections, content cycles, or viral narratives. It will be decided by whether allegations are proven, whether evidence holds, and whether conditions are respected. That's where closure comes from. Or escalation. And now, the only honest question left isn't about Patrick being out. It's about what happens next. What matters more at this stage? Court conditions, evidence, or public pressure? Thank you for watching this video. Click here to watch another video that might interest you.